Good morning, Mr. Dodson.
Good morning, Chief Justice.
How are you this morning?
I'm well, thank you. And how are you?
Thank you very much. I'm well, and I think the commissioners are also well.
Thank you.
Welcome to this session of interviews. But I just want to take this opportunity to thank you for once again availing yourself for consideration for appointment to the Constitutional Court.
You're welcome, Chief Justice.
At least I know of two previous occasions when you have made yourself available. I don't know if there may be more, but I know of two.
Just one more in 1995 when I was appointed to the Land Claims Court.
Yes, okay, all right. Good, thank you. Before we start, I just want to make a few remarks for the benefit of the public. The media spokespersons of the Commission will speak to the media at some stage today, I believe. But I do want to say the Commission had very fruitful and constructive discussion yesterday on its mandate and on various matters connected with its mandate. The spirit was very good, it was very constructive. I certainly benefited immensely from the discussions that we all had. And part of what we discussed was the selection criteria that had been decided by this commission in 2010, and we reaffirmed that they continue to apply. And there was also complete acceptance by everybody without exception that we appreciate it when practitioners and judges make themselves available when there are vacancies that should be filled in our various courts. There was complete acceptance by all commissioners without exception that at all times we intend treating all candidates with respect and courtesy and with due regard to their human dignity, and that we seek to simply try and establish what we need to establish in order to perform our functions in terms of advising the president as to who to appoint in those cases where we are required to advise the president. And that's what we do. There was acceptance that, of course, that we treat all candidates with respect and courtesy. Doesn't mean that there will not be robust discussions and questioning. It doesn't mean that candidates will not be asked difficult questions. They will be asked, but everybody must understand that all that is being done is just to try and make sure that we do our job properly. But the spirit of the discussion was very good, and I thought that it is important that the country should hear that. Thank you very much. Mr. Dodson, speaking for myself, I do not intend to ask you too many questions because I was part of this commission when you appeared before this commission in October. I will ask certain questions just to refresh everyone's memory. It may well be that there are other commissioners who might adopt the same attitude and only ask certain questions. So if you find that maybe you are not asked too many questions or by too many commissioners, that might be the reason. But also, it may be that commissioners will feel that they want to ask you a lot of questions. So, but I thought that I must just mention that because we do have all the papers that have got information about you, your performance as a lawyer, as a judge, and we do have even the transcript of your interview in October. So all of that is before us. So I thought I would just mention that.
Thank you. I've noted that, Chief Justice.
Yes. Now, you have a BCom degree from the University of KwaZulu-Natal, which you got in 1982, is that right?
Correct, Chief Justice.
And you have an LLB degree, which you obtained cum laude in 1984 from the same university.
Correct, Chief Justice.
And you subsequently obtained an LLM degree from the University of Cambridge in 1988. Is that right?
Correct, Chief Justice.
And in 1992, you obtained a postgraduate diploma in tax law from the University of Cape Town.
That's correct.
You were admitted as an attorney in 1987, and you were appointed as a judge of the Land Claims Court when that court was started. Is that correct?
Correct, in 1995, Chief Justice.
Yes, and that was a term of 5 years. Is that correct?
Indeed, a fixed term of 5 years.
Yes, which you completed.
Yes.
And thereafter, you went back to practice, and you got admitted as an advocate.
Yes, it coincided with the time I was also appointed by the United Nations to chair the Housing and Property Claims Commission to deal with property claims in Kosovo.
Yes.
And when I wasn't working in Kosovo, I was busy with my practice back in South Africa.
Yes. And then from 2001, you practiced as an advocate, and 10 years later, 2011, you obtained silk. Is that right?
That's correct, Chief Justice.
Yes. And you have practiced all these years, and that makes it about, what, 21, 22 years?
Somewhere around there.
Yeah. Okay.
As
right.
advocate.
And during the time when you were a judge in the Land Claims Court, you gave many judgments which have been reported, and we dealt with that in October. They are all here. Is that correct?
That's correct, Chief Justice.
Yes. And
there is a list of the reported ones.
Yes, yeah, there is a list of reported ones. You have also got a list of reported judgments where you appeared as counsel. Is that correct?
Indeed.
Yes.
And as an acting judge in other courts.
As well as an acting judge in other courts. And the reported judgments in which you have appeared include judgments where you appeared in the Constitutional Court. Is that right?
Indeed, where I appeared, yes.
Yes, yes, yes. You have a practice that involves constitutional law, administrative law, land matters, and you have got other branches of law. Do you want to tell us about those as well?
Yes, thank you. I am also involved to some degree in labor law from time to time.
Yes.
I have a limited commercial practice, but I do commercial matters on an ongoing basis.
Yes.
I am very substantially involved in the field of medical negligence claims, where I have been trying to develop the common law in a way that will assist I mostly act for the Eastern Cape Department of Health, will assist them in dealing with some of the financial crises that they've been facing by pushing for and seeking the courts to develop the common law in order to change the once and for all rule and develop a new approach to the law of damages.
Well, what I didn't mention earlier on, I must just mention, is something that I did mention in October when you appeared before us, that you have done some work for the commission that I chair at my request.
Indeed, Chief Justice.
Yes. Okay. Of course, last time it did emerge that you have not had a chance to act in the Constitutional Court, but everybody accepts that that's not a bar to appointment.
Yes, Chief Justice.
Yes. Okay, all right. Thank you. You have got no questions? Okay. Do you have any questions? Thank you. Judge President Lekhodi will put some questions to you. I just emphasize to you that by and large, when commissioners ask questions, they will be having due regard to the selection criteria that I talked about earlier on, which were approved by this commission in 2010, to see how you fit in within those criteria. Thank you.
Thank you, Chief Justice. Now I'm familiar with the criteria.
Yes, okay.
Good morning, sir.
Good morning, Judge President.
Let us go straight to one of those criteria. And it is put as follows. Is the candidate experienced in regard to the values and needs of the community? Are you that kind of a candidate? And before you respond to what I'm saying, I'm coming from a place in a village called Ramaja Mutungwa. And my experience in regard to the needs of the community may not be necessarily the same as yours. Now, if you are that kind of a candidate, what kind of the needs of the community are you talking about?
Well, my understanding of the criterion would be to ascertain whether the candidate is a person who has a history of involvement in understanding perhaps all the communities that make up the South African population, but I think it also brings with it a focus on disadvantaged communities and an awareness of how the law can and also very often cannot work for such communities. And I think, as I understand your question, what you would require from me is to indicate where I might fit into that analysis.
Yes.
And in response, I would say that throughout my career, from the moment in fact, before I even got into legal practice, I was very much involved in the legal aid clinic at university. I have focused on trying to make the law an instrument that isn't just there to regulate society, but is also there to come to the assistance where appropriate of particularly rural communities, but also urban poor communities. And I think that was manifested by the human rights work that I did as an attorney. There was quite a strong focus at that time on responding to the brutality of the apartheid regime. We were involved, I was an attorney in Cape Town, involved extensively in resisting forced removal of communities, poor communities, and particularly African communities in the Western Cape. I was involved extensively in representing clients from Crossroads, Nyanga, Langa, who were the victims of severe police brutality, particularly during the second half of the 1980s. And it was in fact that resulted in my being nominated as a candidate for the Land Claims Court. My work in the Land Claims Court was very much focused on addressing the pain inflicted on rural communities in particular, but also urban communities by the phenomenon of forced removals.
I think is enough for now. Other members of the commission, if they want to do, they will make follow-up questions. It's not necessary to give that because we are constrained with time. Thanks, Chair.
Thank you, Judge President. Let me just mention for the benefit of the public and the media that the selection criteria that I referred to earlier on are on the website of the Commission already, for those who might wish to consult them. Thank you. Minister?
Yeah, thank you very much, CJ and Advocate. In the last interview, I engaged you on the Muela's judgment, so I won't go there. I want to hear your view on this one, that you're involved in the land access movement of South Africa and others versus the chairperson of the National Council of Provinces. Why do you think it's important that before we can have an act of parliament that can amend, or an amendment to the Land Restitution Act to reopen the land claims, to first finalize the existing claims?
The motivation there was that there have been terrible delays in dealing with those people who lodged claims by the 31st of December 1998. The impact of the Amendment Act was to create serious problems for the adjudication of those claims and in effect to bring them to a complete halt. In respect of every land claim, you have to check whether there is a competing claim in respect of the same land. So the progress in administering and processing all of those pre-1998 claims suddenly had to stop in order to try and find out whether there were now new claims being lodged. In fact, there might even have been arguments to say that one had to wait for the full period of the new claims lodging before you could deal with those claims. So it created a problem of very, very serious further delay on top of delays of already up to 20 years in the processing of land claims. Also bear in mind that land claimants are mostly elderly people because of the timing of forced removals, and a lot of them were passing away before they ever saw justice. It remains a serious problem. That problem was going to be very seriously aggravated, and hence the need to seek a remedy, which we secured from the Constitutional Court, to say, hit the pause button as far as the new claims are concerned, and let's process those old claims so that they aren't seriously affected. Once those are complete, the new claims are then addressed. And it was left open to Parliament, notwithstanding the declaration of the law as unconstitutional, to continue the reopening of the process. But even those claims lodged under the Act that was struck down are recognized by the Constitutional Court order, so there is no prejudice to them.
No, thank you, CJ.
Thank you, Minister. Commissioner Mapisa-Nqakula.
Thank you very much, CJ. Good morning.
Good morning, Commissioner.
Morning. There is a matter which concerns me when I read your CV and when I read some of the objections which have been raised. And I just want you to help us just clarify this matter, where one of the groups says they've criticized your judgments and philosophy because they feel they are not according with the values and principles of our Constitution. Now, this is just a bold statement which has been made, but no examples have been given to us as to how. Could you perhaps just provide clarity why anyone would make that kind of statement?
The statement is a mystery to me, and I think it's very, very unfair. No information was given. I have never, ever heard of any criticism of that sort ever having been directed at any of my judgments. Unfortunately, I only focused on it this last weekend. I immediately addressed an email to the Commission. I said to them, please give me information about what is behind this criticism. And the Commission said they weren't in a position to take the matter. The Secretariat of the Commission said they weren't in a position to take the matter up with NADEL. What's also strange is that it comes right at the end of a generally positive description of the work that I've done. I simply know of no such criticism, and with respect, it's very unfair. It's very unfair to put a comment like that without any substantiation whatsoever, and I can offer no explanation. I do not know of any such criticism. It's taken me completely by surprise.
Thank you very much. Thank you. Thank you, Judge President.
Thank you, Commissioner. Commissioner Makwanisha.
Thank you very much, CJ. Good morning, Advocate Dodson.
Good morning, Commissioner.
I only have one question. Is there anything that you would want to bring to our attention which could favorably advance your cause, which has happened between the last time we interviewed you and today?
I think that perhaps the only significant thing I could mention is that it didn't happen during that time, but I didn't update my curriculum vitae, and I did act in the High Court during August. So it preceded the previous interview, but I didn't update my CV, so it isn't known there. But in the interim, I've continued my practice as an advocate as I did before, and in the manner that I did before.
Thank you, Advocate Dodson. Thank you, CJ.
Thank you, Commissioner. Commissioner Moimang.
Thank you, Chief Justice. Good morning, Advocate Dodson.
Good morning, Commissioner.
Just one question also from my side. Does the Constitution stand in the way of radical land reform, in particular the legally insecure forms of tenure for millions of people living in communal land in the former Bantu stance to address rural prosperity? Thank you, Chief Justice.
With respect to the opposite, Section 25 specifically addresses the problem of insecure tenure, specifically brought about by apartheid, and calls upon effectively the state to address that and to pass legislation to address that. Legislation specifically in relation to security of tenure has passed. In relation to the so-called former homelands, there was the Communal Land Rights Act. Unfortunately, that act was very poorly conceived. It wasn't correctly passed through Parliament. It tended to favor traditional leaders at the expense of rural communities. And it was the subject matter of an application that I was involved in bringing on behalf of communities to have that law set aside. Where there is a serious gap is that no act has been brought to replace the act that was declared to be constitutionally invalid. And there's a desperate need for that, because if there can be greater security of tenure, if there can be greater clarification and a registration of people's land rights in the former homelands, it creates all sorts of potential for advancing development and prosperity. So there's an urgent need there, and I worry about the fact that I'm not reading anything about that happening. So the shortfall is in the statutory regime. It isn't a shortfall in the Constitution, in my view.
Thank you, Advocate Dodson. Thank you, Chief Justice.
Thank you, Commissioner. Commissioner Nyambi.
Thank you, CJ. Morning, Advocate Dodson.
Morning, Commissioner.
It's linked to the question raised by Honorable Makwanish, but it's asked differently. Of course, you have had some time to reflect about the last interview, as CJ has indicated that you have been interviewed twice. Probably something that you look back that was said then when you were being interviewed that you think you might not have done justice in clarifying the commission, that you might want to do a reflection and make us to seriously consider that particular specific issue.
I believe I had a fair hearing at the previous interview. I was asked some tough questions, but I didn't mind being asked the tough questions, and I answered the tough questions. Perhaps the only thing that I could add is in relation to the provision in the Constitution that requires demographic representation to be considered in, I think it's, I'm forgetting the number now, it's subsection 2 of the 171.2, I think it is. just to make the obvious point that I don't think that my appointment at this point in time, given the demographic makeup of the Constitutional Court, would be a negative factor, because of the fact that frankly there are currently no white members serving on the Commission. So the question I was asked about being a white male, and I don't think my appointment at this point in time, given the Constitution of the Court, would operate as a negative consideration against me. If anything, it could, I would respectfully suggest, operate as a positive one.
Thanks. My last question. Section 167, subsection 2 of the Constitution, where it said a matter before the Constitutional Court must be heard by at least 8 judges. What's your view about this clause in the Constitution in relation to Constitutional Court?
Well, it's unfortunate that sometimes the court is made up of only 8 members. And in fact, I was in the Labour Appeal Court a few days ago, in which we were dealing with what's known as the Hendor judgment, which the Chief Justice will be familiar with, where the court split 4-4. And when that happens, it creates real difficulty for those who are subsequently required, subsequently required to implement the legislation and apply it to other cases. And in fact, a problem has developed in labour law, which is particularly harsh on workers who achieve reinstatement after an unfair dismissal through legal proceedings, in that it's really difficult for them now to claim back pay. So if you have a case that drags on through the Labour Appeal Court and perhaps goes to the Constitutional Court, they get an order of reinstatement, and they then have to, several years down, enforce the order of reinstatement. There's a real difficulty with getting back pay beyond the date of the original award of a CCMA commissioner. And some guidance was provided by the Hendor decision, but it was complicated by the fact that you, as you point out, it was an 8-person bench with an equal split. So perhaps one day when the Constitution is being tinkered with in the future, they could look at changing the provision of 8. I think you've made a very good point there.
Thank you, Advocate Dodson. Thank you, CJ.
Thank you, Commissioner. Mr. Dodson, I may have missed something about the connection between that provision of the Constitution that allows the Constitutional Court to deal with a matter on the basis of a panel of 8. The connection between that and the Labour Court and reinstatement. I just want you to clarify that for me. I want to understand what you were saying.
So all I'm saying is that there's this difficult area of law that has developed in relation to how do you deal with the question of back pay. And the answer is to some extent provided by the Hendor judgment, but it's complicated by the fact that there were 2 judgments there and an even split. 4 of the judges supporting your judgment and 4 of the judges supporting, I think it was the judgment of Justice Matlanga. And it simply makes it a bit more difficult to understand the implications of the Hendor judgment in applying it to that particular difficult situation.
Okay. No, I think I get the idea that if there was a reinstatement order prior to the matter coming to the Constitutional Court, and then when the matter comes to the Constitutional Court, 8 judges sit in the matter and they are split 4-4. That's where the problem arises in the context of a back pay. That's what you are saying.
Yes, it's simply a matter of the
because there is no judgment.
Well, in that particular case, it was concerned. Hendor was concerned more with the question of prescription and how prescription impacted.
Yes.
But the statements that were made there were also relevant to this vexed question of what do you do about the period between when a commissioner granted reinstatement and the matter is finally decided in their favor by the Constitutional Court. And there are all those years that have passed.
Oh, yes.
And what was said in relation to prescription in Hendor does impact on how you answer that question as to how you deal with the question of back pay. And it's become very difficult for workers. Effectively, they've got to bring fresh legal proceedings to be able to recover the back pay.
No, thank you. Commissioner Play?
Thank you, Chief Justice. Mr. Dodson, with the new expanded jurisdiction of the Constitutional Court,
Let me just say before you continue, Commissioner Play, Mr. Dodson, there are commissioners who were not there in October when we interviewed you, so they might feel that they need to know you more. So I just mentioned that.
thank you, Chief
Thank
Justice.
you.
Mr. Dodson, with the new expanded jurisdiction of the Constitutional Court, where the court considers not only constitutional matters, but also matters which raise arguable points of law of general public importance, we do see a greater influx of commercial cases coming through to the Constitutional Court, and undoubtedly the court will be called upon more and more to consider commercial principles against the values.
I'm sorry, Commissioner Play, I wonder whether you might pull your mic closer to you.
I'm sorry, Chief Justice.
Yes, or speak up a bit, yeah.
Can I pick up where I left off, or do you want me to?
No, you can pick up where you left off.
So the Constitutional Court will be called upon more and more, Mr. Dodson, to consider commercial principles against the usual kind of constitutional process of interpretation. Now, against that backdrop, looking at your application, I noticed that in relation to your 10 significant cases that you list, none of them are commercial cases. In fact, your application states candidly that you do limited commercial work. Now, if I can ask you, how do we assess that aspect of your application against other candidates who will be appearing before this body who do have considerably more commercial experience? What's your take on that?
Well, one must be, I think, careful how one describes commercial work. I think the question really, in a strict sense, relates to non-constitutional rather than commercial work. So in the work that I do, certainly poor people often have non-constitutional problems. Because of where I come from, I've acted most of my life for disadvantaged people and poor people, but they run into, for example, delictual claims. The work that I do for the Eastern Cape Department of Health is all about the law of delict and the development of the law of delict. One can consider that is certainly in the realm of non-constitutional work. But I do commercial matters. I was involved in a matter an appeal a couple of days ago in a full bench in Gauteng involving the question of ostensible authority and authority by estoppel. I've in fact done the analysis. I've worked through my judgments in the Land Claims Court, and I can make that available where non-constitutional issues have come up. In addition, if one looks, and I think the point is made by the Bar Council in their review, if one looks at all of my judgments as an acting judge, not just the reported judgments, I've dealt extensively with commercial matters as far as that is concerned. The other area where I've had very substantial and complex commercial experience is that for a period of about 20 years, I've been involved initially as vice chair and for about 10 years until 2020 with the disciplinary committee of the Independent Regulatory Board for Auditors. That brought before me complex commercial matters, complex auditing matters. One of the biggest matters that I was involved there involved the auditors who were the auditors at the time of the African bank collapse. Bank auditing is known to be one of the most complex areas of commercial law that there is, and the reference to the decision that I wrote is in my curriculum vitae. There's a link to it, and that has given me very substantial exposure to commercial law. So I think I would certainly be in a position to deal with that. One must also remember that there's been a unification, particularly a result of the Natal Municipal Pension Fund judgment of Justice Wallace, around how one approaches interpretation in law, and a recognition that it's the same whether one's dealing with the Constitution, a statute, a regulation, a contract, a document in a case. And often litigation and adjudication comes back to how do you interpret the particular instrument that is in front of you, wherever it may come from.
Thank you, Chief Justice.
Thank you. Commissioner Lucas.
Thank you very much, Chief Justice. Good morning, Advocate Dodson.
Good morning, Commissioner.
Welcome once again.
Thank you very
I
much.
think we are beginning to feel like family now.
Happy to be part of the family.
Thank you very much. I was just thinking when I read through all what was written about you or what you have written about yourself, do you believe that there is a room for activism in the judiciary? As a judicial officer, will you say that there can exist a term like judicial activism? That is my question.
So certainly there can be a term, yes, but I think that the term has become, with respect, redundant as far as adjudication is concerned. It's well recognized that we have a transformative constitution that aims to achieve not formal but substantive equality in South Africa. It is a bold constitution, as manifested by the specific provision in Section 9.2 for affirmative action measures, the specific provision in Section 9.4 for legislation that makes discrimination outlawed not just at the level of state but at the level of citizen and between citizens. Related to that, Sections 8.2 and 8.3, and then, of course, the provision for socioeconomic rights in the Constitution. So what I would rather say is that we have an activist constitution, and once you have an activist constitution, as long as the judge comes to the case with the recognition of the fact that it's a transformative constitution, and an open heart as far as that is concerned, I don't think you need to be a judicial activist in order to do justice. It's also important to remember that law is there both as an instrument for the consistent regulation of society, but also to achieve justice. The beauty of the Constitution is that it allows you to meet both of those ends. Sometimes it's a little bit difficult and one sees it wrestled with. An example was this very recent Diamonds decision that came out of the Constitutional Court, where you had the minority judge clearly seeing a particular outcome as being appropriate for a disabled person who'd been injured at work. The majority, however, saw it as a case where the law was clear and it didn't allow the grant of the remedy that that particular worker was striving for. So, short answer, we have an activist constitution. You don't need to be an activist judge.
Let me not ask the follow-up since we agreed on time issues.
Thank you. I'm going to go to the commissioners who are attending virtually before I proceed to the remaining commissioners who have indicated their wish to ask questions. Commissioners who are attending virtually, is there any one of you who wishes to put questions to the candidate?
Commissioner Malema.
Yes, Commissioner Malema, please go ahead.
Thank you very much, CJ, and good morning, SC.
Good morning, Commissioner.
I just have one question. I think you tried to explain it when the other commissioner asked you about the things that you could have done differently or said differently in the previous interview. So I think you tried to deal with it, but let me put it differently so that we are clear when you leave here. Do you think your appointment to the Constitutional Court advances any transformational agenda?
Yes, I do. And the reason I say that is that I accept and adopt and have always accepted and adopted the transformational ethos of the Constitution. And if you have a judge who accepts and adopts the ethos of a transformational approach to constitutionalism, it's going to be reflected in the judgments that they hand down.
I specifically ask about issues of gender and race. So if we appoint you to the Constitutional Court, which of those two are we achieving through your appointment?
Well, if one follows on from what I've already said, I come from a background from my earliest times as a lawyer of finding racial discrimination and gender discrimination an abomination. And the work that I do in the Constitutional Court, were I to be appointed, would reflect that and would contribute to addressing racial discrimination where it continues to exist and gender discrimination where it continues to exist. In terms of the numerical answer, and I don't think transformation is only about numbers. Of course, there's nothing about the fact that I can do that. I'm white and I'm male. I explained my position at the previous interview. I don't want to cover that ground again. I am an African.
Are you done, Commissioner Malema?
Thank you, CJ.
Thank you. Any other commissioner attending virtually who wishes to put questions to the candidate?
Please, Chief Justice, it's Glenis Breitenbach.
Yes, Commissioner Breitenbach, go ahead.
Thank you. Thank you, Chief Justice. Forgive me, I'll keep my camera off because it's raining here and worried about signal.
Okay, all
Good
right.
morning, Dodson.
Okay.
Morning, Mr. Dodson.
Good morning, Commissioner.
My question is a simple one. What, in your view, are the factors that a judge should consider when deciding whether or not he is conflicted? And what would be the factors you would consider in recusing yourself from a matter?
Well, the law has been laid down very clearly, and there's in fact a recent judgment, I think it's of Justice Kampepe, where she dealt with a recusal application in respect of Chief Justice Mogoeng, and it lays down the principles there very clearly. From a personal point of view, obviously I would have to recuse myself if I had a personal interest in a case, or could somehow be said to have a personal interest in a case. I would also have to consider recusing myself if I had made some sort of a statement that suggested that I had a particular view about a matter which favored one of the sides to the dispute. And then there are more concrete examples. So, for example, if I were to be appointed to the Constitutional Court and one of my cases that I'd been an advocate in came before the court, obviously I'd have to recuse myself in that matter. The interesting thing and the important thing that comes out of Justice Kampepe's judgment, though, is that it's also wrong to recuse oneself too quickly. There is a presumption of judicial impartiality. We're trained as lawyers and as judges to be impartial. It's recognized that every human being has their own particular predilections, and one can't simply abandon those when one comes to the bench. But one uses one's discipline as a lawyer in order to put those to one side. It's only when they reach a particular level of interest or association with one of the parties that there's a need to recuse oneself.
Thank you very much. Thank you, Chief Justice.
Thank you, Commissioner. Commissioner Barnard, do you have any questions or not?
Nothing from me, Chief Justice. Thank you.
Nothing from you. Commissioner Shabangu Mdawe, do you have any questions?
Nothing from me.
Thank you very much.
CJ, sorry.
Thank you, Commissioner Singh.
Thank you very much, Chief Justice, and good morning, Advocate Dodson.
Good morning, Commissioner.
I'm here to your right. I think you're looking at the screen now.
I thought you were also being beamed in from somewhere else.
No.
Good morning, Commissioner.
Thank you very much. I had two questions, but I'm going to make it one because my other colleagues have asked the question. During our previous interviews, some of the concerns we had, some of the commissioners had, was your limited acting experience. And in mitigation thereof, you cited your sitting at Kosovo, the United Nations, and your URBA disciplinary board. Now, for the new commissioners and also for myself, again, just to understand this, how do you align that kind of experience with the experience sitting in a court here in South Africa? Because you used it as experience that you had gained. Thank you.
Sorry, just to complete your list, obviously there's the 5 years on the Land Claims Court as a
Yeah, yes,
parliamentary.
yeah,
But
obviously.
are you asking specifically how does my time in Kosovo relate to,
And-
to sitting in a court here?
Yes, and the URBA board.
Well, I'll start with the Urba Court. The Urba Court and Commissioner Kane will bear me out on this because she sat as a deputy chair with me on that. It's effectively running a trial. Cases come to you in the form of trials. There are lawyers there's legal team generally on both sides, and they run as a trial. Evidence is presented by the board and then by the defendant. It's run according to the rules of a trial. And the decisions that we wrote were effectively judgments, although they were called decisions. They reasoned fully in that way. And there's an example which I've attached to one of the decisions to my documentation. So that certainly, with respect, counts. And as I've said, some of those matters were really complex. In Kosovo, again, it was adjudication. It was taking facts. It was applying the law to the facts, and in that process, then coming up with a written decision. But it also gave me exposure to a different legal system. Comparative law, I think, and comparative experience, I think, enhances one's experience as a lawyer. It gives one other ideas that one can bring to bear in the adjudication. It exposed me to international law in operation. International law issues come before the Constitutional Court, and there's frequent reliance on international law. It's required effectively to have regard to it in the Constitution. And the Kosovo experience would give me experience in applying international law. The other component of it is that because I was the chair of that commission, I had to effectively be very much involved in setting up and administering that adjudicative body. So it gave me experience in the practical side of adjudication, in making a court work or making a tribunal work.
Thank you, Chief Justice. Thank you. Thank you.
Thank you, Commissioner Baloyi.
Thank you, Chief Justice. Good morning, Mr. Dodson.
Good morning, Commissioner.
If I may start by making disclosures, I am with you. You're a member of the same group of advocates as I am.
Indeed.
Yes. And a second disclosure, it is that I nominated you. It must have been the first appearance that you had here for the interviews.
Indeed, it was the first one, Commissioner.
Yes. Now, if I may then get to it, in your cases that you have listed, and the ones that you've identified as amongst the important cases, you've referred to the case of Chief Nchabeling and versus Chief Pasha. And this has to do with the requirements for an interim interdict. Now, you say about it that that case, and you sat there with BEMJ, and you say that judgment, or rather what you did there, is to introduce I think you refer to it as a flexible approach to interim interdicts in the Land Claims Court. Now, there's two questions to it. Firstly, it is, what is the philosophy, to the extent that you say flexible, the flexibility in the requirements as it pertains to the Land Claims Court or matters before the Land Claims Court, what would be the philosophy behind flexibility in the Land Claims Court? That's the first question. Related question to that is, how is it that the two factors that you've identified and that you say you take from the Siamite case, the English case, the question of a triable issue, one, and the second one you say, I think it goes to balance of convenience, at least that's what I take of it. Why do those not fit into our common law requirements as they've been established in the normal course? One, which is prospects of success. I would have thought that the question of a tribal issue would fall ordinarily under for consideration under prospects of success. And then the second question, which in this case you determined, was that the applicant would not suffer any prejudice if you granted the respondent wouldn't suffer any prejudice. Why that doesn't fall easily within balance of convenience?
So on the flexibility issue, what It does, and in a sense, it also answers the second question, is that it creates, I think, less of a burden on a party who's coming to court for interim relief to have to demonstrate a prima facie right. And it switches the focus more to trying to regulate what the status quo is. So, as I recall in that particular case, I think there was a problem with one chief settling people on land that was claimed by another community. And it was going to really complicate the land claim by having people newly settled on land that was meant to be subject to adjudication by the Land Claims Court. But the claimant had a relatively weak case. But it was certainly a case that was arguable, and viewed from the perspective of what was best for having a fair hearing ultimately on the issue, it was better that that process of invading the land effectively was stopped so that there could be fair consideration when the matter came before court. So that's why I talk about flexibility. It's a bit less of a focus on the prima facie right and more focus on trying to look at preserving the status quo to ensure a fair adjudication at the later stage. As I understand your question, your second question, it relates to, well, where does that not fit into the current common law? I think that's a very fair question. There are some judgments which are almost indistinguishable from that analysis, and I think I acknowledge it in the judgment. And in particular, it's two judgments of Judge Holmes, later Chief Justice Holmes. The one is Ericsson Motors, and the other is Olympic Passengers. And I, in fact, use those cases to argue that you could apply a similar flexibility. And effectively, what he says is it's a spectrum issue. You weigh, if a person has strong prospects of success, then balance of convenience means less or will have less significance, or the other way around. If you've got weak prospects of success, does the balance of convenience particularly favor a person? And I think your observation is fair. At the end of the day, there's not that much difference between the two.
CJ, I do have a second but unrelated question. I don't know if I should ask it now or give other commissioners
Okay,
the
you
chance.
can ask it.
Please. The last time when you appeared, and I see this from the transcript, one of the issues that we raised is the fact that you seek to be appointed from the bar to the Constitutional Court, and that was debated with you. And in the way that you answered, and I raise this so that I can understand your answer, in the way that you responded, it's capable of being understood, and I don't know if that's what you intended, to be, your answer to be, well, I served on the Land Claims Court, which is a court of similar standing as the High Court. It would be a step back. In fact, you use those words. It would be to take steps back to go to the High Court. And I think if one speaks without too much care, it sounds like you were saying it would be a demotion. Now,
sorry, I didn't hear that word. It would be
a demotion if you went. I mean, and I'm saying, if one speaks without too much care in choice of words, that it sounds like you would be suggesting that it would have been a demotion. Now, the question is, you obviously have the requirements of a judge. That's why you served in the Land Claims Court, right? And that's why you've put yourself up to be appointed to be considered for the Constitutional Court. The question is, well, isn't it a loss to the lower courts, being the high courts, that you do not avail yourself to serve at that level of court, which is, in my view, and you can tell me if you differ, this is the coalface of litigation, the high courts, and one sees that by the number of matters that end up on appeal. In fact, by far the majority of cases do not go on appeal for whatever reason, so they get finally decided in the high courts. Isn't that a factor that you should take into account in your decision not to avail yourself, if you're not nominated or not appointed to the Constitutional Court? Would that not be a factor that you should consider perhaps to avail yourself for the High Court anyway?
Just to clarify on the demotion. I wouldn't see it as a demotion, but I did say it would be a bit like starting again where I started off in 1995. I accepted that I would be able to perform a valuable service in the High Court. I accept that you might term that a loss if I weren't to go to the High Court, but I have served my time, as it were, for a period of 5 years in the Land Claims Court. I've served my time doing other adjudicative work, and I'm turning 62 shortly, and I have, let's say, about 13 years of working life left. And one looks at that time and one thinks, how best can I use that time? I enjoy my practice. I have a practice as an advocate where I believe I make a very significant contribution towards society, and that's the choice that I've made as far as the remaining 13 years of my life are concerned. I would very much like to serve on the Constitutional Court. I think I can bring my own particular perspective and skills and experience to bear there. This commission and the president must decide whether that is or isn't to be. If it isn't to be, I believe I can make perhaps as strong a contribution as an advocate as I do as a High Court judge. And obviously, as an advocate, I will act on a regular basis in the High Court. I will have no hesitation. And because I'm no longer working for the commission, I've resigned from the Independent Regulatory Board for Auditors, I would happily act on a regular basis, not only in the High Court, but also in the Land Claims Court and the Labour Court, were I not to be appointed to the Constitutional Court.
Thank you, Mr. Dodson. Thank you, CJ.
Thank you, Commissioner. Commissioner Tsepe.
Thank you, Chief Justice. Good morning, Advocate Dodson.
Good morning, Commissioner.
Chief Justice, the first question I has been asked by Mr. Singh alongside with the question of Advocate Baloyi. So just a follow up on the issue that that Mr. Singh raised about the issue that you answered to and your experience either sitting at IRBA or in Kosovo and your time at the Land Claims Court. Could you just add to the issue of experience on appeals? If you could do that for me, Mr. Dodson, I just wanted to ask you, given that as a Constitutional Court judge, a lot of the matters that come there are matters of appeal. What sort of experience do you have dealing with appeals? And then I'll deal with my next question. Thanks.
My experience as an appellate judge has been in those cases where I've sat as a full bench while acting in the High Court. In relation to my experience in Kosovo, we had an adjudicative function in addition to the adjudication of the claims, which was reconsideration requests. And there were several thousand reconsideration requests that were submitted, and those were effectively in the nature of an appeal. And that was my experience as far as that was concerned.
Thank you, Advocate Dodson. The question I wanted to raise with you, you touched on it a bit in the last interview, but I want to ask it from a different perspective, and it comes also from the interviews we had during the Chief Justice process, and which is there are issues of delays in finalizing matters in the Constitutional Court. In your response, you said you do not to Commissioner Malema. In fact, last time you said you didn't want to enter into a blame game. What I want to ask you is, what do you think should be done where, as a judge, as a candidate for the position of a Constitutional Court judge, to deal with effective finalization of matters? Because in our view as a commission, effective finalization of matters also help the public to have confidence in the judiciary. So I just wanted to hear your views about what should be happening at the Constitutional Court to ensure that matters are finalized quickly and judgment provided timelessly. Thank you, Advocate Dodson.
I think it's a question of management to avoid those delays. I read an article about the targets that were set by the different courts and achievement of them before this interview, not the previous one. And I did notice that the High Court and the Supreme Court of Appeal seemed to be the top achievers. They were achieving above their target percentages. And I also saw there that the Constitutional Court was below its target. They had a target of 70% completion. They were on 61%. And that was to some extent ameliorated by the fact that there'd been an increase in the caseload. But addressing it as a question of management and discussion and report back. And I think it's when I say management, it's a leadership, with respect, it's a leadership issue. And I think the leader of the court has to find a mechanism where people are required to report on a regular basis on their outstanding judgments, where they have reserved judgment, and to provide progress. And if that is done in a manner where there's level of scrutiny from colleagues, I think it can create the necessary incentive to ensure that you don't have unacceptable delays. And I accept that there have been some unacceptable delays.
Chief Justice.
Thank you, Commissioner. Commissioner JSC.
Thank you, Chief.
Let me just say before we proceed, I think we have taken about an hour with the candidate. I'm just alerting everybody, so we are aware of the time. Thank you. Please go ahead.
Obviously, Chief Justice, my question is only one.
Yeah.
Advocate, it's only one question. It's just a follow-up to Commissioner Bredenbach. What would you regard a situation where a judge sit in the SCA, say over a leave to appeal, dismiss that leave to appeal there, and then goes to the Constitutional Court on the same matter, sit on a leave to appeal in the panel, dismiss that appeal on the same matter? How would you, does that matter? Does that matter fall in the category of recusals?
Yes.
Thank you very much.
Thank you, Commissioner. JSC, Commissioner Matolo Sepu.
Thank you, Chief Justice. Good morning, Advocate Dodson.
Good morning, Commissioner.
I just want to hear you on the Council of the General Council of the Bar mentioned in their comments one of your publications.
One of mine?
Publications, maybe it's a contribution to a publication on post-conflict property redistribution, the approach in Kosovo and lessons learned for the future international practice. I just wanted to find out, looking back, I mean, this was done in 2009, and in South Africa it's 2022. What lessons could we have learned from that input that you made in 2009? Or have you learned anything in South Africa so that we fast track our property and housing issues?
Thank you for that question. I certainly did learn a lot from Kosovo about how it might have been possible to do things differently in South Africa. And in my very first interview, I went through some of those. But just to give a couple of headlines, because I know time is short, I think that there's insufficient collaboration between the Commission and the court. I think that there is inappropriate skill sets that are appointed in the Commission. It's a legal, intense process. Should have been a lot more lawyers appointed to the Commission. I think that there's been a failure to try to find mechanisms of grouping claims so that several claims are heard together. What we did in Kosovo is we would factually group claims that had very, very similar similar facts, and we would decide them effectively in one decision. It requires a very efficient underlying body. The equivalent of the commission there was the directorate, and they would collect all of these cases actively, put them all together, present them to the court so you could decide it in one go. And the result was we were able to get through 29,000 odd claims in a period of 7 years and complete the process. So yes, those would be some of the things that one would have done differently. There are some complexities of South Africa that are different, including the fact that it's substantially rural based. Kosovo was substantially urban based, and the rural component of it makes it more difficult. Also, the fact that it was spread over a much longer period of time. This was a war that took place over 3 months. Yes, at a maximum, a decade if one took into account the discrimination cases. South Africa, we're talking about discrimination between 1913 and 1994. So there must be some fairness to the commission, and the commission is getting there. The last statistic I saw was completion of 72,000 out of 80,000 claims.
Thank you, Chief Justice.
Thank you, Commissioner. Commissioner Traba, is your hand up? Yes. Okay. Go ahead.
Thank you very much. And
Okay.
good morning.
Good morning, Commissioner.
Dodson. Thank you very much. I just want to follow up on the question on the comment on your judicial philosophy. You have acted as a judge. So you were a judge of the Land Claims Court and acted in the as a judge in the High
Just
Court.
1 second, Commissioner Klaver. Can I just get an idea that, generally speaking, everybody hears when everybody speaks? Sometimes I've wondered whether everybody can hear. Generally, everybody hears. Okay. Thank you. Go ahead.
Thanks,
Commissioner Klaver.
CJ. You were a judge in the Land Claims Court, and you acted in the High Court on several occasions. I just want to know if there was any of your judgments overturned on appeal. Was any of your judgments overturned on appeal?
There's a record in the Bar Council's comment of that. There was a judgment where I sat as an assessor in a Labour Appeal Court matter, where I was a majority in the Labour Appeal Court with Judge Farlam, and that was overturned by the Supreme Court of Appeal. I think that's the only one that I'm aware of where I have been overturned. But a judgment of mine, an aspect of a judgment of mine, aspects of 2 judgments of mine, I think, have been criticized. An aspect of the Slumdien judgment was rejected by the Constitutional Court in the Richtersveld case. In the Slumdien, and aspects of the Slumdien judgment were also accepted in the Richtersveld case, and most of it has been accepted. But the one aspect that wasn't accepted from the Slumdien case is where I said that the intention of the Restitution Act was to deal with spatial apartheid, and that aspect was rejected by the Constitutional Court, and they said it went more widely than that, and it was necessary because in that particular case they looked at the way that claims in respect of the mining of diamonds had been dealt with. And it went beyond spatial apartheid. So that's the one aspect that was criticized. And then I understand that my judgment in Khomo versus Standard Bank in relation to the National Credit Act was criticized in a full bench decision of the Gauteng High Court. But subsequently, my decision has in fact been followed by another judge of the Gauteng High Court based on that judge's understanding of the relevant Constitutional Court judgments. So it's only one that I'm aware of where I've actually been overturned, and I was an assessor rather than the judge there.
No, thank you so much, CJ.
Thank you, Commissioner. I think we...
Yes.
Commissioner Dodovo?
Yes, thank you very much, CJ. Just one question. On the question of the land, I thought one commissioner would ask that question.
Parliament has not passed the amendment to Section 25 of the Constitution. In your view, as matters stand, is Section 25 of the Constitution unlawful as it relates to expropriation of land without compensation?
CJ, I wonder who's that commissioner who should have asked that question.
Commissioner Malema is Commissioner Toto, but he's asking the candidate. Yes, Mr. Dodson.
But perhaps it might well be that Commissioner Malema is seeking to say either that question is unfair or it makes no sense or something else. And I think if that is what he intended to do,
I can assure you, Commissioner Malema will not keep quiet. Please, you may respond, Mr. Dodson.
As I understand your question, you're effectively asking, does Section 25, as it currently stands, permit expropriation without compensation? Or have I misunderstood it?
Yes, that's the question. Because there's been a lot of polemics and discussions whether, as it stands, it's unlawful in respect of that point or not.
So the short answer is it is possible to have expropriation, lawfully to have expropriation without compensation under Section 25 of the Constitution. And there are two ways in which that can happen. The first is if one applied those criteria in Section 25.3 that govern the determination of just and equitable compensation. If one applied those factors and an application of those factors led to an answer of 0, it would be lawful to give expropriation without compensation. So just by way of example, if it could be demonstrated by the state that that particular landowner had been subsidized by the state both by way of interest and by way of capital improvement to an extent that equaled, for example, market value, the person could then be expropriated without compensation. But the other legal route to it is that you also, at the end of the day, even if you couldn't justify expropriation without compensation with reference to the Section 25.3 factors, at the end of the day, one must always come back to the limitations clause in Section 36 of the Constitution. And if on a proper application of the limitations clause in Section 36 of the Constitution, you found that notwithstanding that perhaps some compensation was payable under Section 25.3, that was a justifiable limitation, you could also end up at a figure of 0. The practical answer to your question is that the expropriation bill is still there. Yes, the amendment to Section 25 has fallen, the constitutional amendment to Section 25 has fallen away, but the expropriation bill is still there. It's got, I think, a non-complete list, I think, of 5 different circumstances in which there can be expropriation without compensation. And look, I think the first of those, the one about land being held on a speculative basis, might come under debate, but they look okay to me. The provisions in the bill look as though they may well withstand scrutiny under the existing version of Section 25. So I hope that answers your question.
Oh, thank you, CJ.
Thank you, Commissioner Dodovo. I don't know why Commissioner Malema asked the question that he asked, but it is possible that he was thinking the Constitution being the supreme law, it can't be unlawful. So it's other laws that can be unconstitutional. So maybe that's why he was asking. I think we have come to the end of this interview. Mr. Dodson, we've come to the end of this interview. I don't know whether before I release you, there are only 2 or 3 matters you consider important to emphasize to the commissioners before you leave for purposes of your candidature?
Chief Justice, I think it's been covered well. I think that it was, with the greatest of respect, a good idea to put up the transcript of the previous interview. And if I look at the previous interview and the current interview, I've been given a very fair and full hearing. I don't think there's anything that springs to mind that I need to revisit. Just to thank all of the commissioners for the hearing that they gave me. I have responded to the one negative comment from Nardel. I don't think I can say anything more, not knowing what the basis of it was. So thank you very much, everybody, for hearing me. Thank you, Chief Justice.
Okay, thank you very much. You are now excused.
Thank you.